Hey all, welcome back to the Law Read Slowly. We are discussing the Code of Civil Procedure. In the last session, we began discussing the topic of plaint. We went into the details of plaint. We first discussed the trajectory of suit, which is going to stay with us throughout this series, and we will keep coming back to it. Because what is civil procedure? It's nothing but a manifestation which is telling you how will a civil suit be conducted. So civil suit is basically a picture of your code of civil procedure in practice. So we went to the trajectory of civil suit. We saw how a civil suit proceeds. We picked up plaint as the first element that we're going to discuss. In plaint, we have begun in the last session by seeing what are the components of plaint. Once we've laid out the components, we begin discussing each component of the plaint in detail. In the last session, I told you how a plaint looks. First, it has an index. In the index, you will put down all your components, all the particulars of a plaint. That is why you also need to put page numbers in your plaint. So that is how you will prepare your index. In the index, you will have serial numbers for the particulars. In the particulars, what will you have first? First, you will put memo of parties, which is your first thing in the plaint. What is memo of parties? Memo of parties is simply the information of the parties. Who is the plaintiff, plaintiff's parentage, because there might be more people with the same name as the plaintiff. So you have to specify with details who is exactly the person who is a party in the suit. So your plaintiff, son of, daughter of, so-and-so, resident of, so-and-so, everything, the address goes into it. Then you put plaintiff under his name. Then you write versus, then you put defendant's name, defendant's details, and you write defendant. You put your date, place, and your advocate's details on the right hand side. So whose advocate's details will go on here? Of course, the plaintiff's. If you see at this stage, the rule is that plaintiff's advocate will go there. But even if you see logically, only advocate in the picture at this stage is plaintiff's advocate, because you're filing a plaint. When you file a plaint, then eventually, as we have discussed, summons will go. Then defendant will get notified about the suit having been filed against him. Then he will engage an advocate, and then the advocate of the other side will come into the picture. Remember it by that logic. So on your pleading, you put the advocate details. The advocate details are the advocate of the party whose pleading it is. So in the defendant's pleading, which is what? Written statement, orderate. The defendant will put the details of his advocate. Why is it important? Court needs to know who is going to represent this party in the court. So you put the advocate's details. So memo of parties. What comes after memo of parties? After memo of parties, you put down the next page, which is going to be your main part of the plaint, which is beginning from here. So you put down what? Put down in the court of the name of the court, leave a blank for the suit number, put the particulars of parties once again, put the head, the title of the suit. What is the suit about? In our example we took in the last session, we are talking about the suit for specific performance of contract. So we put that heading. Then we started making our submissions to the court, making our pleadings to the court. Most respectfully show at : para 1. In the last discussion, we discussed logically what all needs to be there in a document in which you're trying to get somebody to give you a relief. You will tell them what the issue is, what the problem is, how this problem arose. Why am I asking you to give me a relief? What kind of relief do I need from you? Why should you give me this relief? How am I entitled to this relief? What is all of that in the formal language of CPC? Cause of action. First thing is cause of action. To establish a cause of action, first you will tell that you had a right. Then you will tell that right was violated. And you will tell anything else that the law may require you to fulfill with respect to that cause of action. So for a specific performance cause of action, you need to prove that there was a contract, which is establishing the rights. That is how you get the right as a plaintiff, by the contract. So you establish that there was a contract. In that paragraph only you can write what the contract said. Contract was for the sale of immovable property, so and so, the details of the property, for a sale price of so and so. You will mention the price of the price agreed upon, which was signed by the defendant and the plaintiff. Or you can write which was mutually agreed to by the defendant and the plaintiff. That is how you will make it. Then come to next paragraph. Now you have to establish the breach of this right. Now there's no fixed format in which you have to move. So it's about how you tell the story to the court. So here you may write more facts first. You may write that in pursuance of this contract and to fulfill my part. So if you as a plaintiff are buying this land from the defendant, you will say that the defendant was owner of this property and there were no encumbrances. That is how you are omitting any possible excuse for the defendant to use in order to shirk his part of the contract to be performed. So you will mention I have also, if the contract said that you will make a part payment, you will write that I have made a part payment of so and so rupees to the defendant on so and so date by way of, if a check, then mention the check number and the details. And you can also write it has been attached with this plaint for your reference. In the first paragraph also, where you make a mention of the contract or the agreement, then you can mention please refer to an extra number this, which contains a copy of the agreement or contract. So you will give, in the second paragraph, you will tell that you have already paid the partly you have paid the amount which was agreed upon, which was supposed to be paid before the sale, and that you are still ready and willing to perform the contract. That is, you are ready to pay the rest of the amount, and it's already, maybe you've already given a post-dated check to the defendant, something like that. But then in the next paragraph you can write that the defendant has not performed his part. He has neither tendered any instrument to transfer such property, neither is he showing up at the date at the registration office, because to make any sale or any kind of immovable property transfer of more than rupees 100, it has to be by a registered document. Who will register it? You can't register it at home. Registration is done by the registrar at the registrar's office. In local parlance, sometimes it's called kacheri. That's where you go to get the documents registered, your instruments, the sale deed registered. And plaintiff has shown up and on the agreed date at the registrar's office. Defendant has failed to show up at the registrar's office. You will mention all that facts. So here you have completed the 3 elements of the suit for specific performance, the cause of action that is required. So you established the right by showing that there was a contract, you established the breach of it, and by showing that you have always been ready and willing, and in fact you have performed a part of your contract side, you have given the part payment, so you will show readiness and willingness to perform the contract. Not only then, but even today. You will write in that paragraph, even today I am ready to pay the money if the defendant is ready to transfer the property to me as per the terms of the contract. This is the part till where we had discussed. Now let's proceed from here. Before we move on to actually take it down and see what comes after this, let's talk about it. Now this was your cause of action. What comes next? Then come your technical pleadings. Technical pleadings can be about what? Jurisdiction. In the beginning I told you, logically when you're asking somebody for a relief, that somebody will question you, why have you come to me for this relief? Why am I supposed to give you this relief? So you will establish the jurisdiction of that authority. In this case, the civil court. How will you establish the jurisdiction? You will say that the dispute arose within your territorial jurisdiction. That's why you have the jurisdiction to try this civil suit. And what? You will also say that the amount of the property involved, the valuation of this suit is this much, suppose 5 lakhs. And you are the court which is eligible to try a suit of this much amount. Your pecuniary jurisdiction is accordingly met here. And hence I am here. What is the third? Subject matter jurisdiction. You don't need to mention it explicitly. It is already clear from your plaint that it is a civil suit, a suit of civil nature. I've told you briefly that civil courts can try only those suits which are of the civil nature. So if your suit is not of the civil nature, civil court can't try it. That is roughly your subject matter jurisdiction. So you will talk about jurisdiction. What else will you talk about? There are some defenses that the defendant can outrightly take against you. That this case has already been decided, this issue has already been decided by another court. Why is he here again to file this case? So in your plaint only you can mention that this suit, this plaint has not been filed in another court ever before. In a more formal language, I'm telling you what you put in it. So this is what? This is your res judicata and res sub judice both. Res sub judice says that you can't go to another court while your case is pending in one court. Res judicata says that you can't go to another court after your case has been finally decided by one court. So if you hadn't filed, which you are declaring in your plaint that I have never filed it, there's no possibility of it having been ever decided or being pending. So res judicata and res sub judice. So you will put all these technical pleadings, different technical pleadings you will put. You will put about limitation also. So for a suit for specific performance, I told you what is limitation. Period of limitation is the time that you have from the date when the cause of action arises to file a case with respect to that cause of action, to file a civil suit with respect to that cause of action. What tells you this period of limitation? You have a law called the Limitation Act of 1963, which lays down all the sections, the rules, the law with respect to period of limitation. How will the period of limitation be calculated? What if it's a Sunday? How will you count the Sundays in that period of limitation? What if you have a period of limitation? Period of limitation means on any of the days in that period you can file your civil suit. And you decided I will file it on the very last day of my limitation period. But the last day is Sunday, the courts are shut, the filing counter is shut. But you have a right to file it on any day. Sunday is also one of those days in that period of limitation. Then what will happen? Limitation Act tells you about it. What if you met with an accident on your way to the court? I know I make a lot of people meet with accidents in my discussions, but those are the examples you have to take, the real life examples. Because anything less, if you're not able to make out a case, you will not get a relief from the court. So suppose you were on your way to the court with your plaint to file your suit, to institute your suit. You met with an accident, you're bedridden for quite a few months. In the meantime, your period of limitation has run out within which you could have filed that case. Now what will happen? You will go to the court. Will you directly go to the court and ask it to exercise its inherent powers? No. There is a solution provided where? In the limitation law. That is also answered. This was just to tell you that there's something called limitation which is governed by the Limitation Act. So in your plaint itself you will say, because limitation also becomes an explicit ground on which your plaint can get rejected. It's covered under Order 7, Rule 11. I'll tell you the clause later. Because it is not explicitly written there. We read it into the provision by a very roomy clause that is there. So period of limitation is also becoming a technical pleading. So in your plaint you will mention that this was the date on which, so by that whole story that you have written, in that you will mention, right, that this was the exact date when plaintiff asked the defendant that please perform your side of the contract, and defendant refused. So his refusal is what gave birth to this cause of action. And from that date, of course, your plaint is mentioning the date itself on the very first page we saw. So no need to mention it, but you can, in the technical pleading, you will mention that I am filing this plaint within the period of limitation.